An uprising of Aboriginals along the Indiana-Ohio border in 1791 set the stage for the first investigation by Congress of decisions in the executive branch. President Washington, then in his first term, sent Major General Arthur St. Clair into the wilderness to put a stop to the raids. General St. Clair and his 1,400 American soldiers were camped along the headwaters of the Wabash River on November 3 when they were surprised by the attack of a strong force led by Little Turtle, chief of the Miami. The Aboriginals killed more than 600 officers and men and forced the others to retreat. Congress demanded an explanation. On March 27, 1792, the House of Representatives appointed a committee to inquire into the failure of the expedition, and to call for such persons, papers, and records, as may be necessary to assist their inquiries. For the first time, the President and his cabinet were presented with the problem of whether to make papers and testimony available for congressional review. President Washington called a meeting of his cabinet to determine the proper way to proceed, for he was aware that the action taken would set a precedent on such matters. Thomas Jefferson wrote the following account of the meeting and the conclusions drawn by the Washington cabinet. First, that the House was an inquest, and therefore might institute inquiries. Second, that it might call for papers generally. Third, that the executive ought to communicate such papers as the public good would permit, and ought to refuse those, the disclosure of which would injure the public. Fourth, that neither the committee nor House had a right to call on the head of a department, who and whose papers were under the President alone, but that the committee should instruct their chairman to move the House to address the President. Hamilton agreed with us in all these points except as to the power of the House to call on the heads of departments. He observed that as to his department, the act constituting it had made it subject to Congress in some points, but he thought himself not so far subject as to be obliged to produce all the papers they might call for. Although the cabinet indicated a need for a discretion to withhold papers which would injure the public, President Washington agreed that in the case of the St. Clair expedition there was not a paper which might not be produced. There was one other instance in Washington's administration in which the Congress asked for executive papers. In this case, the House of Representatives asked for the papers and instructions to United States ambassadors who negotiated the Jay Treaty. This time Washington refused to deliver the papers to the House on the specific constitutional grounds that the Senate, not the House, is authorized to advise and consent on treaty matters. The Marbury versus Madison case in the administration of President Thomas Jefferson raised the question of whether it was possible for the courts to force the cabinet to perform certain acts required by law. In the last hours of the administration of President John Adams, a midnight appointment was made of a justice of the peace for the District of Columbia named William Marbury. James Madison, who became the new Secretary of State in the Jefferson administration, refused to deliver the commission to Marbury to complete the appointment process. Marbury asked the Supreme Court to force Madison to deliver the commission. Chief Justice John Marshall delivered the opinion of the court. First he dealt with the question of whether Madison had a right to refuse to deliver the commission to a properly appointed official. The decision was a rebuke to Secretary of State Madison and stated, "Is it to be contended that the heads of departments are not amenable to the laws of their country?" Although Madison was wrong in withholding the commission from Marbury, the court held that under the Constitution there was no way to force action. The case did not mean that Madison had a legal right, but only that Marbury had no remedy. The specific question of congressional access to executive papers was raised in one case in the Jefferson administration. In 1807, President Jefferson was requested to furnish the House any information in the possession of the executive on the allegation of a conspiracy by Aaron Burr. President Jefferson displayed an awareness of the dangers of arbitrary withholding of information by carefully explaining the nature of the papers he did not deliver. He stated that these papers included matters chiefly in the form of letters, often containing such a mixture of rumors, conjectures, and suspicions as to render it difficult to sift out the real facts and unadvisable to hazard more than general outlines, strengthened by concurrent information or the particular credibility of the relator. Later, when Aaron Burr was tried for treason, Chief Justice Marshall issued a subpoena for papers in Jefferson's custody, including a private letter from General James Wilkinson to Jefferson. Marshall's decision conceded that the president could not be summoned to make a personal appearance before a judicial body because of the nature of his position and the dignity of his office. A Senate investigation of land frauds in the Andrew Jackson administration resulted in demands for papers dealing with land transactions conducted by a Jackson appointee. President Jackson refused to deliver the papers to Congress, but the resulting cover-up of land frauds could hardly be called a precedent worthy to be followed. After the Civil War there was a flurry of investigations, but these caused little conflict. The corruptors in the Grant administration were foresighted enough to bring key members of the Republican Congress into their dishonest schemes as an insurance against exposure by the committees of Congress. The widespread scandals of the Grant administration presented no basic problem for Congress in obtaining government records because the key evidence in these cases could be obtained from sources outside the executive branch. However, a problem did develop in 1876 when the Democratic House sought to obtain testimony and records of financial transactions of J. Cook and Company, one of the largest financial institutions of the time, and J. Cook was close to the Grant administration and Republican Party politics. When the House of Representatives discovered that the Secretary of the Treasury had deposited large sums of money with a London branch of the company, it sought to determine whether there was some impropriety involved in the decision to make the deposit. In the course of its investigation, the House issued a subpoena for Hallett Kilburn, who refused to produce the documents sought and argued that the House had no right to investigate private affairs. The House ordered him arrested for contempt. Kilburn was imprisoned by House Sergeant-at-Arms John Thompson. Kilburn immediately obtained a court order for his release and then sued Thompson for false imprisonment. The Supreme Court held that Thompson was liable for damages, and in the decision threw a doubt over the right of Congress to punish witnesses for refusing to answer questions or produce records. The decision upset the long-standing view that the power of Congress to investigate was as broad as the almost limitless power of inquiry of the British Parliament. The Supreme Court stated, "We are sure no person can be punished for contumacy as a witness of either House, unless his testimony is required in a matter into which that House has jurisdiction to inquire, and we feel equally sure that neither of these bodies possess the general power of making inquiry into private affairs of the citizen." President Theodore Roosevelt refused to allow his Attorney General to deliver papers to the Senate dealing with the status of investigations involving the United States Steel Corporation. The papers included an Attorney General's opinion on the case. Although the papers sought involved a pending case, the Senate insisted on pursuing the matter. Herbert Smith, head of the Bureau of Corporations, was summoned and was threatened with contempt and imprisonment if he failed to produce the documents. President Roosevelt asked Smith for the papers and, after taking them into his possession, informed the Senate the only way they could get the papers would be by impeaching him. The Senate then dropped the matter.